Okay, here we go. I'd like to welcome everybody that's joining us for our fifth webinar in our Lunch and Learn series today. My name is Barb Mendenhall. I'm the project manager for the EPA 319 grant with the Sangamon County Soil and Water Conservation District and CWLP. This Lunch and Learn series is an opportunity for us to reach out to anybody that's interested in learning about water quality for Lake Springfield and anything agricultural. We're also including the Lake Springfield Regional Conservation Partnership Program, also known as RCPP. This grant, 319 grant, and the NRCS funding pools work to provide education and outreach and producer funding for conservation efforts to improve water quality in the Lake Springfield watershed. Before we begin, if you would like to be on the mailing list for the Lake Springfield watershed or the Sangamon County Soil and Water District newsletter, either email or by address, just contact Jake Vansel, Shelley Seaman, or Sarah Lindholm. Their contact information should be on the screen in the chat section. Just before we start, our Lunch and Learn webinar series are held on the second Wednesday of each month through November of 2022. We did not hold one in April, and we will not be holding one in October due to harvest. Our webinars focus on current important topics in agriculture that also pertain to soil health and water quality, covering information on agricultural, urban, and stormwater BMPs, current future carbon market opportunities, waters of the U.S. permitting updates, conservation considerations to farm leasing, farm rents, and landowner responsibilities, solar and wind leasing opportunities, and woodland improvement with invasive species removal. Today's webinar, Farm Leases with Conservation, Farm Rent, and Landowner Responsibilities, will be presented by Mark Cochran and Andrew White, attorneys with Bellatti, Barton, Cochran and White LLC, law firm in Springfield. Mark Cochran joined the law firm in 2000 following a 20-year career at Central Illinois Public Service Company, better known as CIPS, where he had management responsibilities over the environmental, fuel, and power generation departments. He managed a comprehensive long-term study of Lake Springfield following that service to CIPS and the impacts of farming practices on the lake's water quality. And he's worked with several local soil and water districts and the state of Illinois on various conservation programs. In 1977, Mark received his Juris Doctorate cum laude from Indiana University and was admitted to the Illinois Bar in 1979. In addition, he has a degree in environmental engineering from Purdue University. His areas of interest include real estate, estate planning and administration, environmental compliance, government farm programs, electric and gas utility regulation, and conservation easements. Andrew White joined this law firm in 2011 and concentrates his practice in areas of estate planning, trust and estate administration, real estate, and taxation, with an emphasis on agricultural law. He received his undergraduate degree from the University of Illinois in agricultural economics and a Juris Doctorate from Ohio Northern University College of Law. Andrew is the Illinois State Bar Association's acting Council of Legal Education chairman of the Agricultural Law Section Council and a member of the Energy, Utilities, Telecommunications, and Transportation Section Council. We're pleased to have these two gentlemen with us here today. And I'd just like to remind everybody that's on the webinar to please make sure that your mute button is on. And also, if you have any questions that you want answered by Mark or Andrew, please type them in the chat box and we will take care of those after the presentation by Mark and Andrew. So if anybody has no questions, I will go ahead and turn this webinar over to Mark and Andrew.
Thank you, Barb. I'm Andrew White. I'm going to start off today and I'd like to thank Sangamon County Soil and Water Conservation District and CWLP for inviting us to participate. The portion of this talk I'm going to start out with is I designed it with a landowner in mind, wanting to educate themselves on leasing issues, especially with conservation and soil health and stewardship issues in mind. I see our audience is a pretty appears to be a pretty educated audience. That type of landowner may not be out there, but I hope they are, and I hope they're listening, or I hope that they can catch this program later as it's being recorded. So we're talking farm leases in Illinois. Most of you probably know the cash rent agreement is king, at least in central Illinois on row crop agriculture. Cash rent is easy. Cash rent's the first type we'll talk about. Second type is what was more predominant 40, 50 plus years ago. That's your basic, that's your crop share agreement. And third type is a hybrid of those two. So we'll get into that more here in a minute, but cash rent agreements are popular because they're simple and they're relatively low risk for landowners. Landowners viewing this as an investment always or generally tend to go toward a cash rent agreement because there's a stable flow of income, because they're low risk, and because it's easy. You cash your check at the end of the year, you trust your tenant's going to do the right thing, and you treat this like an investment. Those are the pros. The cons to your cash rent agreement are that these are often very short-term arrangements. Often it's a one-year deal with a tenant who moves on to the next farm. That means stewardship issues, conservation issues are likely not going to come to the forefront, and those things often suffer on a cash rent agreement. Second type, on a crop share arrangement, those are less popular than they used to be, frankly, because I think they require more work for the landowner. They require an educated landowner who knows what he or she is doing. Oftentimes it means that landowner needs to know how to market grain, know how to talk to their tenant, know how to have some checks and balances in place to make sure the bushels that are being turned over to the tenant are correct, are accurate, are in line with area averages. Those crop share arrangements, though, mean a complete share of both the risk and the reward. It often leads to a long-term partnership between landowner and farm tenant, and that partnership often leads to a better stewardship issues, better conservation issues, better long-term outlooks, a longer window where your tenant is working alongside your landowner to develop and maintain the property, soil health, soil quality, erosion issues, because they expect to benefit from them. The tenant, that is, expects to benefit from that lease and from those improvements long-term. That's as opposed to a 1 or 2 year short-term cash rent agreement where the goal is simply, for better or for worse, to make as much money as possible. So the third type I mentioned in the introduction was a hybrid or a bonus type lease approach. These are becoming much, much more popular as a way to oftentimes give the landowner some base income protection, but also provide a way to benefit in terms of a good year, good yields, good markets, without simply asking the tenant to take all the risk on those things. So what does that mean? What's a hybrid or bonus lease look like? There are dozens of types and dozens of formulas. The most basic version, I think, is setting a cash rent rate, which is below market value. If, for example, the farm would rent for $300 an acre cash rent, maybe your hybrid lease provides for $175 an acre base rent, and then with a different a bonus calculation if the yield or the market prices or both reach certain levels. That seems to be the most popular version we've seen through our office. There's another type that's used out there that simply takes a fraction of the gross revenue from the farm. So at the end of the year, it's bushels times market price at a set date, and then a percentage is applied to that gross income, and the landlord gets a percentage. That percentage may be 30%, 35%, 25%, somewhere in there. A lot of risk share in that, so that's more like a crop share arrangement. But in the crop share arrangement, the landowner is also paying for half of the inputs and chemicals and fertilizer, whereas in that hybrid or bonus lease, that's not the case. So that's an introduction to the basic types of leases. If you're that landowner looking to educate yourself, looking to maybe be more assertive, maybe to make changes, maybe to think about soil health or land stewardship, first thing is communicate with your tenant. If you've got one, start the conversation. These tenants usually are doing more on the their personal land that they own to care for the soil because they're worried about future generations. They may not be doing those things on your farm because they've only got a 1-year agreement and they want to keep you happy. They don't want to lose this farm. So have the conversation with your tenant first. Second, the handshake deals have worked in the past and it's probably still working in the future. But if you're trying to make changes, have a written lease. If you want to protect your waterways, if you want to protect your erosion issues, if you want to implement cover crops, if you want to leave those options open, make sure you have a written lease. Now, Mark and I are attorneys. We do this for a living. You can obviously seek legal counsel for this. You can also look at the University of Illinois Farm Doc website. There's a great bank of lease forms that have been trusted by both landowners and by farm tenants for a long time. Those forms are a good place to start. You can plug in the basics and then you can add additional information. Recently, Farm Doc put out some addendums to their forms, which allow landowners to take the traditional form that's trusted by the farm tenant and the landowner and add on extra information regarding soil health, conservation habitat practices, nutrient management practices. There's a lot of blanks in those pages. It's going to take some education, some conversation with your tenant, but you take the base form, you incorporate those extra items by reference. Now you have a written agreement with your tenant that they must follow these rules, be it soil health, be it nutrient management, be it conservation habitat issues. So communicate and get it in writing. We're talking University of Illinois. I'm a U of I grad, so I probably talk it more than Mark does. He's a Purdue grad, but that aside, we can also look to U of I even on some cash rent issues. We can look at what they've done. In 2017, U of I's, we'll back up a little bit. University of Illinois owns a lot of farm ground that's been gifted to the university through the years. There was a time when they decided farm tenants simply by putting those farms out for bid. The highest tenant got the farm, period. And that didn't take into account a lot of the land stewardship issues that maybe the university had in mind, or even the family who gave the land away to the university had in mind. It was simply, again, business to the highest bidder. In 17, that shifted away. And while it's still a cash rent model, the university first asks their tenant applicants to basically enter a beauty contest where they're judged on their education, their stewardship history, their soil conservation knowledge, drainage history, and reputation in the community. Those are all pretty important things that you landowners are probably looking for when you're trying to find a tenant anyways. University just made it into writing and made it look more like a job application. And then when they decided on who was going to best care for this land, they then applied what they decided was a fair market price to the farm. So could there be some cash left on the table? Possibly. But if you're tuning in here and you're approaching this from a conservation perspective, a little cash left on the table is a good trade-off if you've got an operator you can trust, an operator who's going to take care of the farm the way you want it to be taken care of. I've got a few more minutes here. Things to think about for a landowner, landlord that are new, that your father, grandfather, grandmother didn't have to think about. We're seeing increased interest in a lot of energy and environmental issues. As a landowner, you are getting letters from carbon companies. Carbon sequestration contracts are coming your way. Solar contracts are coming your way. There's pressure from organic interests wanting to rent your land. Those are all things that are going to turn your lease on its head. Not only the issue of who shares in the extra income, who shares in the expense, but just making sure you can even do these things on your land if you have a basic cash rent agreement, which gives your tenant full possession of the property. You've certainly got to consider what those carbon sequestration letters mean. You've got to consider the long-term contracts you're signing. What do I mean by carbon sequestration? There's two different types. One is your traditional soil health, soil and organic matter being used as a carbon sink or carbon deposit to hold carbon that's not going into the atmosphere. We're seeing a lot of action on that across the Midwest from companies who want to pay landowners or operators a little bit of money per acre if they can show records that their practices are increasing carbon sequestration into the soil. The response from the farming community has been, I'd say, lukewarm at best on those things. There's a lot of pushback from those operators and farmers who have been using good stewardship practices and no-till practices for decades. And they're essentially almost punished in this scenario because it's those landowners who start with a low baseline of soil health who are now getting paid to now bring the soil up to standard. So that's one issue. And another issue we're seeing is many of these programs seem to be a big data grab for, I'm not sure who or to be used for what, but there's a lot of farmer and landowner data that's given away in exchange for a little bit of money per acre. So I guess enter into those things with a lot of caution. They don't pay real well. If the goal is soil health or carbon sequestration, I mean, you can do those without signing a long-term contract. The other type of carbon sequestration we're seeing, particularly here in central Illinois, Christian and Macon counties especially, are some projects which would actually, they're called geological carbon sequestration, where emissions from generally ethanol plants in Iowa, South Dakota, and now in Illinois are being reduced to liquid. And the plan is for pipelines to carry that liquid carbon to certain areas in Illinois that contains a sandstone or a limestone structure capped by shale, that they can inject that liquid carbon, with the idea being that it is stored in perpetuity under the surface rather than being released into the atmosphere. Our office got involved with some of that when there was a federal project called federally backed project called FutureGen, where we developed some of the agreements for landowners who were concerned about this carbon being injected under the surface of their soil. And a lot of questions, a lot of issues. Contracts being presented by these private parties today are a little scary for a landowner because they're perpetual and the lease is not. The lease is a short-term right for this company to inject something under the surface and then essentially walk away. Now there's some federal and state safeguards in place that are supposed to protect the situation, protect the soil, but that's still a little unnerving. And the takeaway here for a landowner getting those types of letters is that these companies do not have eminent domain authority. They can't take your subsurface to inject carbon. They might someday, they don't today. They might get that right to take your land for a pipeline. Pipelines have been doing this forever. As you know, they could come in if it's a needed project, they meet the standards with the Commerce Commission and with the Energy Commission. They may be able to acquire the pipeline against your will, but not the deep subsurface injection under the surface. So no matter how good the salesman is who's pitching this to you, there is no requirement that you sign up or enter into any of those types of projects. We've got another presentation coming up in August where we're focusing on green energy, utility type issues, wind and solar in particular. I mentioned them today just because they do factor into your leasing decisions now. I don't want you signing a 5-year farm lease that gives your tenant full possession of the property. Then you sign a solar lease after year 2 that lets a solar company come in and turn the farm into a power plant. Your tenant could have recourse against you, the landowner, if that lease gave them full possession of the property. So just things to think about and calculate and factor in when you're redoing your farm leases. But we'll hit those more in August. And then also, you may want to think estate planning a bit, at least long-term, when you're thinking about farm leases. Illinois still has one of the more aggressive estate taxes in the nation. It doesn't take much farmland for an owner to hit a $4 million tax exemption in Illinois. And there are times when the type of lease you have matters very much when it comes to calculating estate taxes. If you're simply a cash rent landlord, you don't get any breaks under what's called a special use election or a 2032A election. Whereas if you are actively participating in the farm through a crop share agreement, you can also often save a lot of money in Illinois estate taxes because you're still deemed to be a family farmer. So just keep that in the back of your mind when you're negotiating farm leases long-term. Mention that to your attorney, whoever's handling your estate plan, what type of lease you have, and you may want to make changes based on that, in addition to the other factors we talked about earlier. I'm going to turn this over to my partner, Mark Cochran. Mark's going to hit on a few more landowner responsibilities and conservation options in probably more detail than I hit there. Mark Cochran.
Andrew said I'm going to talk about some landowner responsibilities, and they could be tenant responsibilities or shared responsibilities. But what I'd like to kind of emphasize is some of the downside or consequences of a landowner not really paying attention to these responsibilities and making sure that they're addressed in an appropriate manner. I think the first area I want to touch on is wetlands. I think all of us are familiar with wetlands, maybe not the technical definition of them, but they've been in the farm program for a long time, and there's a lot of visibility and attention to them, rightfully so. And it's got some major consequences of not carefully following what those wetland provisions are out there. And one of the first things a landowner or tenant should be aware of, virtually every acre of farm ground in Illinois at one point has been classified as far as its wetland status. And your landowners and tenants should be aware and review those maps that are available at your local farm office that show what designations apply to the different tracts. And that's important because if they're designated as wetland or prior converted wetlands, there are a whole host of requirements that apply to those. And you may have heard the term swamp buster. And swamp buster is where an owner or operator can really get themselves into trouble. If they go in and work an area, it may not be apparent that it was a wetland or it's classified as a wetland. If they go in and cut trees along a waterway or do some work and maybe add an acre or two here, put it into production that someone's classified as wetland, that can generate a whole host of negative results for the landowner. The landowner and operator have to make periodic certifications that they're in compliance with these wetland provisions as well as highly erodible. And those get reviewed and audited. And there are whistleblowers out there. If someone thinks that a farmer has converted a wetland and put it back into production or put it into original production, you know, there are whistleblower provisions, and then they can start an investigation. And what you need to really keep in mind, the consequences of these can be catastrophic, because if they're found to be wetland violations, one, they can order the ground restored to its pre-wetland condition, which can be pretty onerous and may not even always be possible. The tenant or owner could have changed, and the person responsible may not have control over the ground. So there are issues there. But more importantly, there's loss of eligibility for farm program payments. And they're not just for the current year. They can go back for all the years the non-compliance was in place. So depending on what program payments, you know, these can be thousands, if not hundreds of thousands of dollars throwing in interest that the government's going to be seeking reimbursement for. So it's extremely important to know what your wetland classifications are. Make sure you or your tenant avoids any activity that could impinge on those areas that are wetland. Coupled with the wetlands is the highly erodible, the HEL. And like wetlands, the operator has to make a certification that they're in compliance with the highly erodible provision. And essentially those are farm ground that have considerable slope to them, where there's obvious erosion concerns. And where there's swamp buster with respect to wetlands. With the HEL, there's sod buster provisions. So if you're going in and opening up a new area, may not be in wetlands, but still, if it's a new crop production, you've got to go through your local farm office and have them come out and make a determination, primarily if the ground is highly erodible. Because if it is highly erodible, before you can break it open and start farming it, you're going to have to develop a compliance plan, you know, in terms of, you know, how you farm and no-till, contour plowing, whatever conservation plan the local farm office comes up with, then you're going to have to abide by that plan in order to be able to farm that new ground. So those are two areas that are very important, both, and you need to, as a landowner, you need to keep tabs of what your tenant's doing and make sure he's not, one, he's complying with the conservation plan, you know, he's no-tilling if that's required, or he's not cutting trees or clearing areas that could be potential wetland areas. So that's, as a landowner, that's your primary responsibility, because you can get bit by that just as well as the tenant. And these issues would with respect to Lake Springfield, they would all have direct impacts because of the wetland and the highly erodible. They're all, if there are violations of those or questionable practices, they potentially could impact the watershed in Lake Springfield. I'm going to touch on a couple areas for landowner responsibilities that maybe are not so directly involved, but one, and in our practice, we've seen over the last 10 years, a lot of drainage issues come up. And some of you may have experienced it, but they can be very annoying, very time consuming, and very expensive to resolve. I think probably most of you are aware that there's a common law of drainage law. Essentially, you know, water flows downhill, so a farmer that's upgrading has a right for his ground to drain to his neighbors that's below him. And that neighbor that's below is called a servient owner. He has an obligation to accept that water. Those are the kind of the broad outline, but there are a lot of gray areas within that. Because one of the things that has evolved over the years that, you know, the upgrading owner is allowed to increase the flow and velocity of water coming off their ground. This lot comes in a lot of tiling that's taken place in the last 20 or 30 years. You know, it allows for quicker dissipation of surface water hitting ground, and that's allowed. But starting to play into that now, there's in the farming context, there's reasonable use limitations. So it can't have devastating effects on the downstream owner. So, you know, there's a balancing there. So you need to consider that, you know, when you're looking at tiling projects and keep, you know, your neighbors informed and make sure that there's not any bad reaction once it's put into place. And to give you some examples, these are real world cases. And, you know, I'm obviously not giving the names or location, but one of the things under the common law drain, you can't impede the flow coming onto your ground. I've had cases where there's been a fence line separating two properties for years and years and years. And along the fence line, there's 5 or 10 feet that's been left fallow. It's grass, and it's just been the practice. The owners die, the next generation comes in. One of them decides, well, that grass strip there is keeping my water from flowing onto your property in the way it should be. So they go in and tear it up and plow it and kill all that grass. That's an invitation to a lawsuit, which in this case, it took 4 years to resolve, and it was a minor issue, but you get entrenchant owners, it becomes personal. You get issues where you've got a field tiled, it drains down and outlets near a neighbor's property. Over the years, the tile collapses. You know, it could be 100 years old, and the farmer said, well, I'll just outlet it on the surface and let it go. But when he does that, it's taken from being underground and onto the surface of the neighbor. It floods him out or backs him up. And that's just another example where it just breeds an opportunity for litigation to resolve that. You also have to keep, we've had cases where people think that their farm ground, they can use that, you know, if they've got excess fill somewhere, they'll come out and place it in their field somewhere. But you got to be careful there, because that if you place that can build, it's like building a dike or an impoundment. It can interfere with natural runoff, and that's another case where you may be buying yourself a lawsuit. And these lawsuits, you know, you get into these gray areas. They take years to resolve and considerable money. And another area where we've seen under the common law, you know, water goes where it naturally does and flows to a natural watershed. But the law has evolved that's fine, but you can't take water from one watershed and divert it into a different watershed that it wouldn't normally flow to. So what we've seen, or I've seen, a number of tiling projects where, whether it's the tile person or the landowner, or they're together, what they do is they install and lay the tile in such a manner that it diverts the normal surface runoff into a different watershed, which helps their situation, but that additional water in the neighbor's property may overload their waterway or create problems for them. So that's another example of where you have to be very careful with your drainage decisions and what you do, because in those cases, you go to court and they're probably going to lose, and the court's going to order them to reestablish, to abandon that tile system, to put it back the way it was, plus pay damages. So it's important to know your rights and limitation when you're looking, because there's a lot of, you know, activity in drainage tile, you know, but you got to be careful. And I caution you to make sure that your neighbors are going to be impacted, to let them know, or to see if they want to cooperate in a joint endeavor on that respect. Final one I'll just touch on briefly are spraying issues. We see cases, you know, where there's spray damage on a neighbor's property. And I think is the owner or the operator that's got the ground that's going to be sprayed, I think it's incumbent on you to make yourself aware of potentially sensitive situations. You know, if you got a neighbor that's raising bees or producing honey, or they got enrolled in a pollinator FSA program, you may want to think about having a buffer there where you're not spraying, or certainly being attentive to weather conditions and wind conditions. I know a lot of you are going to be using a vendor to do the spraying, but make sure that they're responsible and alert them to any sensitive issues. Make sure that they have adequate insurance coverage. You know, these claims can get substantial if real damage occurs and it's traced back to the spraying activity on your property. I briefly switched to some conservation opportunities. Many of you may be knowledgeable or aware of the CREP program, which was the Conservation Reserve Enhancement Program that came in about 20 years ago. And it was a cooperative program between the state and federal farm agencies. And it was very successful in Sangamon County and Central Illinois, all through the state, where sensitive environmental ground, meaning ground primarily in floodplains or that was highly erodible, could be taken out of production with substantial payments to the landowner. That program expired and the funding went away, but they're currently in the process, or at least considering reopening CREP. And I think that's incumbent to keep an eye on that, because that can provide some really cost-effective opportunities to benefit, plus to have substantial conservation benefits by putting those practices. Typically, those would be repairing filter strips, you know, in floodplains along the edges of your fields. And if those programs open up, that would be a really good place to go to see if you have a mind to preserve your economics, but also enhance the conservation practices being employed on your ground. Another area is that we've talked, this program is being funded with a 319 EPA grant. Prior to that, a similar 319 grant funded a project that grew out of the long-term Lake Springfield watershed study, which was a filter strip program. It provided incentives for landowners in the Springfield watershed to put filter strips along the stream corridors in the watershed. And that had a pretty good level of participation. That could have been better, but those are practices that are in place now, that have been in place probably for 10 years now, that have had substantial benefits to the Lake Springfield watershed in terms of controlling not only sediments, but also some farm chemicals, particularly atrazine, from entering the lake. And another opportunity out there that I think is worth checking, at least, is with Springfield City Water and Light and Power. Over the years, have had money, I would say it's more in cost share money for certain projects that would benefit Lake Springfield in terms of the agricultural inputs coming into it. That's another area that I think for landowner or his tenant would want to contact the city water, light and power periodically to see what's available and see whether they might have some applications that they could put on their farm with some cost sharing from the city. Probably the most economic one for landowners are the various FSA programs, because they provide a cash rent for 10 to 15-year contract terms. And probably the most typical one that would help in the Lake Springfield would be filter strip enrollments. But there are also field borders, which aren't dependent on stream presence. You know, they're available along borders of any field. And those would all be important tools to help control both sediment and chemical runoff from fields. And there are also nutrient management programs under various FSA programs. And I think it's good for any producer or operator to periodically check with the local office and Jake Vansel to make sure they're familiar with what your farm situation is, what the ground is, and explore just what programs USDA would have available that might be, possibly be enrolled into to both create an economic benefit and a conservation benefit. I think the last thing I wanted to touch on, another approach that can have substantial conservation benefits as well as very substantial economic benefits to the landowner are the concept of conservation easements. And these are legal tools where a landowner would put restrictions on their ground, not really with respect to farming. They're still allowed to farm and, in good conservation practices, but the ground could not be developed or put into a less conserving practice, like a subdivision or some type of commercial development. And these easements, typically they're perpetual, so that's kind of a scary thought to some landowners, but it's perpetual to keep the ground in farming mode so they can be farmed forever. And the trade-off from the landowner, in addition to the benefits of the conservation practices that are ensured there are very substantial federal income tax and estate tax potential savings from doing these projects. So I think any particularly long-term family farm operations that have an interest in continuing farming for generations, that's certainly an area that they might want to explore, both in terms of preserving their farm as a farm, plus getting real substantial tax savings. So I would, if you're in those circumstances where you've got a family farm and you want to preserve it, to take a hard look at a conservation easement potential. And I think with that, so I think we've got questions. I don't know if we've got any submitted here. We can check.
I don't see any questions yet, Mark. We might be off the hook.
Well, if anybody can think, it will be on here for a few more minutes. If anybody wants to follow up or raise a new topic that we didn't touch on.
I have a question on conservation easements. Would putting a farm in a conservation easement protect it from, say, development, or say a municipality decides they want to put a road through, or a utility company wants to put a power line through, or anything like that? How much teeth does the conservation easement have in preventing those types of things from happening?
Well, I'd say yes and no. Example where it does, it protects you from the landowner changing his mind or the heirs wanting out of it. I mean, it's enforceable, it's perpetual. If there's a death and change in ownership and a son or grandson inherits and wants to get rid of the easement and develop it, he would be in general prohibited from doing that by the conservation easement. He could try challenging it in court, but I think in most cases those are upheld. A private company coming in wanting to put in, a wind farm that doesn't have eminent domain, the conservation easement would give you some comfort. If there's a condemnation and there's a governmental taking of it, that would probably trump your easement. And in that case, the easement holder, some land trust organization, would share in part of the proceeds from the condemnation along with the landowner. Because in these tax benefits, the amount of the tax benefit is based on the reduction in value of the property because of the easement. So if it's condemned, the easement holder, which would be this conservation group, would get the portion that reflects the reduction in value, which is another way of saying that's the value of the easement. And the remaining portion would go to the landowner. So, I mean, it's kind of a jump around answer, but it provides some level of protection. It's not a ironclad guarantee that it couldn't be condemned by a government authority. Good question, though.
Do we have anybody else out there that wants to jump on with a question?
I have another question regarding drainage. Say there is a neighbor that wants to drain their farm ground. You are the lower landholder. The upper would prefer to drain, but you do have a watershed boundary on that piece of property. Whose responsibility is it to make sure that that is whatever's being drained is being done legally, or to have the survey done to prove that it would have to that whatever area they're draining is not within another watershed?
Well, let me answer a couple of ways. First of all, it's the responsibility of the landowner that is initiating the drainage project. That he has to be sure what he's doing is not going to, it's going to stay within its natural watershed. The tile, assuming you're using a tile contractor, they would have that obligation too, because they have to do a survey and map it out and come up with the plans. And they should know the elevations and know where it's going. And so they should not develop and submit or implement a tiling plan that's going to violate this watershed integrity. If the affected landowner suspects this is happening, obviously then they starts a dialogue with the landowner and say, hey, look, you can't do this, you need to redo this. And assuming that can't be worked out, then your option is to file suit for a trespass violation of Illinois drainage law and let the court resolve it. And the remedy, assuming you prevail and that what they did was a violation of the drainage law, that they did divert it, they would have to put it back the way it was and pay damages. I would like to add, I was going to add in my initial comments, sometimes you get in these situations where somebody wants to tile, they don't have an outlet at a stream or a road ditch, but they need to go across a neighbor's to get to an outlet. You can try and negotiate that and agree on a common plan or get permission, but under Illinois statutes, if you're doing that and the downstream person refuses to allow you to come through to create a new outlet, you can file suit to have a court order the downstream landowner to allow access for the placement of a tile to run through their property to get to an outlet point, a road ditch or a stream. To do that, the person who's wanting the tile projects, has to have it surveyed, has to come up with a specific plan, identify the outlet, come up with an estimate of what the damages are to the downstream landowner, deposit that with the court, go through a hearing process, establish that what they're proposing is correct within drainage law, and get a court order. And then the damages are put in, escrow, and the project is completed, and the affected landowner gets his damages and gets the property restored. But when it's all said and done, he's got a tile going under his ground that's connecting to an outlet source. And that's by statute in Illinois, so that people can have a way of draining their property if they don't have direct access to a stream.